Hello. So today I will do a presentation that I choose the topic based on my test one from the course MGM 4331. First I will introduce myself. So my name is Ayla Zulaika binti Shamsuddin and my matrix number is TX03520. So today I will present about termination versus dismissal in employment. So all the acts is according to Employment Act 1955 and also other acts that was related. Okay, let's get started. So first I'm going to talk about the definition. So definition for termination is removal of employees from the service, and it can be voluntary or from the side of employer, such as layoff or retrenchment. For example, if an employee remains absent for a long period of time without giving any prior intimation to employer, that employee can be terminated from the service as unauthorized absenteeism is a misconduct. So next is dismissal. So dismissal is the act done by employer which result into termination. Dismissal usually occurs when is wrongful act done from the side of employees. For example, if an employee misbehaves with his superior or beat him, which is treated as against the code of conduct of a company. In such cases, the employee will follow the process of dismissal, which will result into termination. Such will committee will decide or the domestic inquiry follow the proceeding to dismissal such employees. So next, I will share about the termination of contract notice. So for the first section is section 12 from Employment Act 1955. So termination with notice is either party to a contract of service may at any time give to the other party or a written notice of his intention to terminate such contract of service, but it's only allowed for the following reasons in the section 12. And second is the section 13. So the termination of contract without notice. So the first one is either party to contract of service may terminate such contract of service without notice, or if a notice has already been given in accordance with section 12, without waiting for the expiry of that notice by paying to the other party an indemnity of sum equal to the amount of breach. Second, the party to contract of service may terminate such contract of service without notice in the event of any willful breach by the other party of condition of the contract of service. So the third one is the section 14, continued termination of contract without notice. An employer may, on the grounds of misconduct inconsistent with the fulfillment of the express or implied conditions of his service, after due inquiry, dismiss without notice the employer. So the last one is section 15. Employee shall be deemed to have broken his contract of service with the employee if he has been continuously absent from work for 2 consecutive working days without prior leave from his employee, unless he has first a reasonable excuse for such absence, and B, second one has informed or attempt to inform his employer of such excuses prior to or at the earliest opportunity during such absence. So next we will continue about the termination of the contract of employment under the Malaysian law. So there are several things that how do people terminate from the of uh, contract of service. So the first one is death to employees. Second one is resignation. And then the termination under section 13 in bracket 2, section 12 in bracket 1 in Employment Act 1955, and the breach of contract under section 15 Employment Act, misconduct, poor performance, termination at the end of probation period. And then expiry of fixed term conduct, frustration of contract, changes of business ownership or closure of business, insolvency, redundancy and retrenchment or VSS. VSS is voluntary scheme. And the last one is retirement. Then now I will discuss about termination versus dismissal. For in the private sector's employees, is there any difference between termination of employment and dismissal for private sectors? So for the first, termination of the employment contract either by the employee for specific reasons such as retrenchment or by employee when he's resigned. So it's according to Ayadurai 1998. Second one is dismissal, an act of employer to terminate the contract of service unilaterally from Ahmad Mir and Kamal in 2013. So in this case, dismissal is a form of termination of employment where an employee is dismissed due to misconduct, negligence or poor performance. For the case that we refer is Great Wall Shopping Sdn Bhd and Geng Shang Eng Award 241 of 1998. So next is the employee termination or dismissal must be with just cause and excuses and the common law principle of termination simpliciter. In example, a termination by contractual notice and for no reason is not applicable in view of Section 20 of the Industrial Relations Act. As example, the federal court in the case of Gun Hui Poi versus J&P Courts in 1981, the health is we do not see any material difference between a termination of the contract of employment by due notice and a unilateral dismissal of a summary nature. The effect is the same and the result must be the same. Second one is in Dr. A. versus Asunta Hospital. The how is there is no material distinction between dismissal and termination. Either must be with just cause and excuse rule be justifiable. So therefore, for private sector employees, they cannot be terminated without just cause or excuses, either summary or not with notice. So now I will share about from the public sector's employees. So make distinction between termination and dismissal. For appointment at pleasure of the YDPA or statute ruler, government servants can be terminated at pleasure by giving notice or payment in lieu of notice to end the contract, according to the doctrine of leisure. And then the termination of service differed from dismissal in that it did not ipso facto initial forfeiture of eligibility for a pension in the case, for example, case Mahan Singh versus Government of Malaysia in 1978 and appeal number 5 of 1976. So public servant can be terminated at any time at the pleasure of the Crown subject to restrictions under the federal court. And then contracts employees employed by government can be terminated. The same case, refer to the same case that I mentioned before. Second, only if dismissed, right to be heard should be given in Article 135 Federal Court. Dismissal carries a penal element as a form of punishment. So that's all from me, and thank you.